Welcome to LexiCast, a podcast designed to help you grow in your legal practice, with weekly updates on current topics, trends, and practical insights. Perfect for listening on the go. Let's dive in.
Welcome to the deep dive. For those of you listening, our legal professionals out there, you know that the courtroom is an environment built entirely on control, right? The architecture, the rules of evidence, the solemnity of the bench, every single variable is meant to be heavily curated.
But the second you step out of that room, you're in a completely different paradigm. I mean, you pull out your smartphone and you are thrust into this impulsive, unfiltered, instant gratification machine.
Yeah, a total contrast.
Exactly. And for decades, the legal architecture treated those two worlds as completely walled off from one another. You know, you had the law and you had the internet.
But that wall just doesn't exist anymore. So today we are looking at a stack of sources detailing social media's impact on Australian law.
And it is a massive impact.
Huge. Our mission for this deep dive is to explore how this digital landscape is forcing the entire legal system to scramble. And specifically, we're going to look at the absolute havoc this is wreaking on jury trials.
Yeah, the jury box where it gets really volatile.
Right, because we want to know what actually happens when the ultimate uncontrollable variable, a smartphone, enters that highly controlled environment of the jury box. Okay, let's unpack this because social media is no longer an external problem for your clients. It has become a Trojan horse sitting right inside the justice system itself.
It really is an infiltration. But before we get to the jury box, I think we need to establish the thematic through line connecting everything happening in the broad legal landscape right now.
Yeah, set the scene a bit.
Exactly. Because you're already seeing this in your daily practice. Across defamation, advertising, and privacy, we're witnessing this massive shift of liability. The law is essentially forcing digital platforms and businesses to become the gatekeepers of truth and privacy.
Let's actually test that theory with defamation, because I think this is a perfect example. Historically, if a defamatory statement was published, you track down the original author. That was the standard.
Right.
But social media just obliterated that model. You have anonymous trolls, bot networks, fake accounts. Finding the original author is basically impossible now.
So the courts had to find a new target. What's fascinating here is how recent high court decisions have firmly shifted the legal burden onto the page administrators.
Right, the businesses themselves.
Yeah, the mechanism here is critical. The courts basically decided that if you create a public forum, like, say, a Facebook page for your business, and you actively invite engagement, you are facilitating the publication of whatever third-party comments appear there.
Wait, let me make sure I'm following how this works in practice for our listeners. If I represent, like, a local plumbing business, and a random customer leaves a highly defamatory comment on my client's Facebook page about a rival plumber, is my client suddenly legally classified as a publisher of that defamation?
Potentially, yes. Think of it like environmental regulations implemented back in the 1970s.
Okay.
For a long time, factories could just dump waste into the river. Eventually, the law stepped in and said, hey, if you own the factory, you are responsible for the pollution it creates. We're seeing the exact same thing with digital pollution. If you administer the page, you are responsible for the digital waste left on your property.
So it's like the Wild West suddenly getting a sheriff. It seems like the law is finally trying to build fences around the internet, but, well, is it moving fast enough to catch up?
That's the million-dollar question. And the federal government is certainly trying to codify this. They introduced that initial wave of defamation reforms back in July 2021, requiring plaintiffs to demonstrate serious harm.
Yeah, the serious harm threshold.
Right. But the January 2024 reforms, that is where the rubber meets the road. It's specifically aimed at intermediaries. It outlines highly specific exemptions and content removal processes to clarify exactly who is left holding the bag when something defamatory stays online.
Oh, wow. And this gatekeeper shift extends straight into consumer law, too, right?
Absolutely. In November 2023, the
ACCC
implemented a new penalties regime, specifically targeting deceptive digital advertising.
Because it spreads so fast online.
Exactly. The
ACCC
realized that misleading conduct on social media spreads exponentially faster than, say, a misleading print ad ever could. The repercussions for disseminating false content in the digital economy, even accidentally through an unchecked automated campaign, are becoming incredibly steep.
I want to look at the Privacy Act reforms through this same lens, actually, because data breaches are just dominating the news cycle right now.
Oh, totally. It's everywhere.
Right. And the incoming changes are pushing for secure handling of user data, but the downstream effects are what our listeners really need to watch.
Well, especially regarding the small business exemption.
Yes. For context, currently, if a business has an annual turnover of less than $3 million, they're largely exempt from the act.
Right.
But if that exemption disappears, what is the practical reality for, say, a sole practitioner or a boutique firm?
It's massive. It means enterprise-grade compliance falls directly onto their shoulders. Thousands of small businesses and law firms themselves actually will suddenly be subject to the full weight of the Privacy Act.
That's a huge operational shift.
It really is. You'll have to map exactly where client data lives, overhaul how it's stored, and align with strict new privacy thresholds. I mean, it completely rewrites standard legal advice for small business clients.
So the law is desperately trying to build this regulatory fence around the internet out in the corporate world. But if regulators are struggling to control digital behavior at the corporate level, how on earth do you control 12 random citizens in a room?
You really don't.
Right. Let's move into the jury box.
This is where the friction between legal tradition and modern human habit becomes highly destructive.
To put the habit into perspective, the sources note that nearly 80% of Australians use social media, and they're averaging over 100 minutes a day scrolling and researching.
That's a huge chunk of time.
It is. That is a deeply ingrained physiological loop. And nobody just magically rewires their brain the moment they take an oath as a juror.
They definitely don't. And what makes juror misconduct via social media so difficult to manage is that it's nearly invisible.
What do you mean by invisible?
Well, a juror looking at their phone during a recess looks identical to everyone else in the building. You have no idea if they are checking a text from their babysitter or scrolling through a defendant's criminal history on Google.
Oh, yeah. That is terrifying. The sources actually outline some staggering examples of this research phase. Like, in 2014, a Queensland murder trial made it today.
10 days in.
10 days of expert testimony, emotional exhaustion for the families, massive public expense. And it was completely aborted because one juror decided to do some background research on Facebook regarding the accused and the victim.
And the courts don't take that lightly. That juror was actually referred to the Attorney General and faced up to 2 years in jail. The courts treat this as a direct assault on the process.
Wow. 2 years.
Yeah. And then in 2016, a criminal trial saw a jury discharged because 2 jurors Googled the background of the accused. They were prosecuted for contempt and hit with $3,000 fines.
Here's where it gets really interesting, because Googling a defendant's background is an obvious violation. I mean, we all intuitively understand you shouldn't look up a defendant's prior convictions.
Right. That's basic.
But look at the 2021 Queensland perjury trial. This involved a former police officer, and it was aborted for something that sounds completely innocent. A juror used their smartphone to look up the dictionary definition of the word intention.
A word that was absolutely central to the charges.
Right. But to a regular person on the street, looking up a word in a dictionary is just being thorough. It's like double-checking the measurements on a recipe to make sure you get it right. Why does looking up a simple definition trigger a mistrial?
It comes down to a fundamental clash of models. You can call it the collision of contexts.
Okay.
To the internet, information is entirely about access. But to the legal system, information is entirely about admissibility. The core mechanism of the adversarial system is the right to a fair trial based strictly on evidence that has been tested.
Tested through cross-examination, right?
Exactly. So when a judge defines intention for a jury, they are providing a highly specific legal definition shaped by centuries of case law and precedent.
Yeah.
When a juror bypasses that and pulls up a colloquial definition on their phone, they're essentially introducing unvetted, untested evidence into the deliberation room. They strip away the legal context, and by doing so, they completely bypass the adversarial process.
And once that unvetted definition is shared with the rest of the jury, the whole pool is tainted.
Completely tainted.
And this goes right to the top of the judicial system. In 2022, the High Court unanimously quashed the conviction of a tutor accused of sexual offenses against children. They had to order a brand new trial purely because one juror conducted online research before the verdicts were delivered.
It is the ultimate systemic failure. Think about it, an appellate court overturning a serious conviction because of a few keystrokes on a smartphone.
It's staggering. But researching is just passive consumption, right? You're just absorbing information. Social media platforms aren't built for passivity. They demand interaction. They want you to broadcast and connect.
Yeah, commenting and connecting are where the real danger lies. If we connect this to the bigger picture, what we're really talking about is the psychology of the modern citizen.
Okay, unpack that a bit.
Well, people are deeply conditioned to narrate their lives in real time. They post what they eat, what they think, where they are. But the legal system demands this monastic discipline. Jurors are instructed to remain completely silent about the case. For someone used to broadcasting every thought they have, that isolation feels completely unnatural.
And the urge to broadcast clearly overrides the judge's instructions in many cases. Look at the 2019 New South Wales sexual assault trial.
Oh, that one is brutal.
It is. The day before the jury was supposed to hand down a guilty verdict, a juror posted on Facebook about putting dogs down when they attack children. And they paired that text with a photograph of an electric chair.
Think about the mechanics of what happens when the court discovers a post like that.
Yeah.
The defense doesn't have to prove that the juror actively corrupted the other jurors. They just have to show a demonstrated lack of impartiality. An image of an electric chair in a sexual assault trial is so highly prejudicial that the NSW Court of Appeal had no choice. They quashed the conviction and ordered a retrial.
And beyond just broadcasting opinions, there is the networking element. There are strict rules against communicating with parties involved in a trial, but the digital barrier to friending someone is frictionless. It takes half a second.
Literally a tap on a screen.
Right. In Florida, a juror was actually sent to jail for 3 days for sending a friend request to the defendant on trial.
And we saw a variation of this right here in Australia with the Woolworths fraud trial.
Yes. The $4.7 million kickback scheme. An incredibly complex, highly expensive trial. And it had to be entirely paused because multiple members of the jury had become Facebook friends with each other and were posting comments about the case online.
The danger there is the creation of an unmonitored back channel.
A back channel, right.
Jurors are supposed to deliberate only in the jury room, all together under very specific rules. When they friend each other online, they create a private forum to discuss the case that the court cannot see and cannot regulate.
Which undermines the entire process.
Completely. In the Woolworths case, the judge ultimately ruled that the specific information communicated wasn't prejudicial enough to discharge the jury. But the sheer panic that must have gripped the courtroom when that was discovered, it just highlights how fragile the whole system is.
So what does this all mean? With mistrials costing massive amounts of time and money, causing immense emotional damage to victims, and delaying justice for the accused, how do courts practically fight back against an ingrained behavioral addiction?
It's the subject of intense debate right now. The Tasmanian Law Reform Institute, the TLRI, recently spent 2 years researching this exact issue, and their primary recommendation is a massive shift toward pre-trial education.
Wait, education? Are we just talking about giving them a pamphlet and telling them not to look at their phones? Because history shows that just doesn't work.
No, not just a pamphlet. The TLRI recommends comprehensive, context-heavy training at the courthouse before a jury is even impaneled. And this is combined with highly specific, modernized directions from judges.
So explaining the why.
Exactly. The strategy is to explain the mechanics of why a Google search destroys a trial. You treat them as intelligent participants in the justice system. Show them that collision of context model. If they understand how outside information actually bypasses the adversarial process, they are far more likely to comply than if a judge just barks a blanket ban at them.
I understand the theory behind education, but there are much more extreme suggestions floating around too. Some legal advocates are calling for a return to sequestering jurors, physically isolating them in hotels, or, more commonly, just confiscating their smartphones entirely while they're in the courthouse.
Which is incredibly controversial.
Well, I have to push back on the confiscation idea myself. I mean, taking away someone's smartphone today is like severing a digital limb. People manage their entire lives on these devices: childcare, banking, elderly parents.
You are identifying the exact logistical nightmare that researchers warn about.
Right. If you tell a group of 50 potential jurors that they have to surrender their phones for a 6-week trial, suddenly every single one of them is going to discover a medical condition or a family emergency that prevents them from serving.
And that is exactly what experts like Loranda Bartels argue. She's an assistant professor in law and justice at the University of Canberra, and she pushes back heavily against draconian measures like phone confiscation.
It just alienates people.
Completely. If you alienate the jury pool by making the courts seem fundamentally out of touch with modern reality, you destroy the concept of a jury of your peers. The only people who will agree to serve are those with no external responsibilities, which completely skews the demographic makeup of the jury.
So courts are trapped. They have to protect the absolute integrity of the trial, but they can't alienate the public they rely on to run the system.
Exactly. It requires a highly nuanced balance. Courts have to trust jurors, but verify that trust through modernized, context-based education. The goal isn't to fight technology. The goal is to integrate a profound respect for the legal process into a digital mindset.
That makes a lot of sense. So, to summarize what we've unpacked today, social media is not just a marketing tool or a public relations issue anymore. It is fundamentally reshaping the architecture of legal practice.
On every level.
Yeah. Whether you are advising a sole practitioner on enterprise-level data compliance because a Privacy Act exemption is vanishing, or you are a litigator watching a multi-million-dollar trial teeter on the edge of a mistrial because of a dictionary app, the digital world is forcing the law to react. The shift of liability is making everyone a gatekeeper, and the legal profession has to evolve just as fast as the technology.
But the thing is, the technology isn't pausing to let us catch up.
Not at all.
We've spent this deep dive talking about the damage a simple smartphone can do today. But I want the listeners to consider what happens tomorrow.
Okay.
Imagine a near-future scenario, perhaps only 5 years away, where jurors walk into the box wearing augmented reality glasses or even smart contacts. Devices that look like standard prescription lenses but are passively receiving AI-generated context.
Oh.
Imagine a juror looking at a witness on the stand, and their glasses silently project the witness's entire digital footprint, criminal history, and social media commentary directly into their field of vision in real time. How does the justice system even begin to police an influx of unvetted information that it literally cannot see?
That is a terrifying operational challenge for the next generation of lawyers to figure out. Thank you so much for joining us on this deep dive. We'll catch you next time as we continue to explore the forces shaping the legal landscape.
That's it for today's episode on LexiCast. If you're looking for more in-depth episodes that can also be claimed as CPD activities, check out our LexiCast CPD Plus page linked in this episode's notes. Follow us now to stay up to date, and we'll see you next time.